Hey guys, Chicago injury lawyer Scott DeSalvo here, and in today's video I want to talk to you about slip and fall cases or fall down cases, right? Doesn't matter if you fell at work or at a store or at a restaurant or even on somebody's property. Basically the topic is I don't want you to fall in the personal injury fall down case bear trap, right? There's a big trap that insurance companies use in fall down cases to beat injured people's cases and pay them no money, and that's what I want to talk to you about, right? So here's how it works, okay? A lot of people think you are on somebody else's property. If you get hurt, they got to pay you, that's it, right? That's not the law. It's never been the law. Sometimes people say it's the law. It's not the law. In every fall down case, in order to recover for you, we have to prove that the owner or manager of the property knew or should have known about a problem on the property. Let's say there's a hole on the ground or something, right? Or it could be grease on the floor, it could be water on the floor, whatever it is, right? So what we're talking about is a situation where in order for, so we can't just point at the hole and say, pay the bills. I mean, we can, but then they're going to laugh at us and walk out, right? We actually need to prove what Illinois law requires us to prove to get you money in a case like that. And Illinois law requires us to prove that the problem, the hole, the grease, the water, whatever it is that caused you to fall, was created by the property owner or manager, or that it was there for so long that they should have known it was there and fixed it. Now, they defend these cases all the time on saying, oh, we didn't know about the hole. Oh, we didn't know that the water was there. Oh, we didn't know the grease was there, right? So, for example, I got one case where Jewel has a leaking freezer, and rather than shut the freezer down and shut the aisle down or block it off, they just push those, those like beanbag things you put at the bottom of a door to keep the draft from coming in. They pushed a bunch of beanbag, those long beanbag things up against the freezer to stem the flow of water. Well, the water kept coming, right? So anyway, that was like one case. In that case, they really can't claim they didn't know because they put beanbags up against the freezer. Instead of unplugging the freezer and closing the aisle down, they did a half-assed repair, right? Those are, really good cases. But in any fall-down case, we got to prove that they knew about it for long enough to fix it, or that they took unreasonable steps to fix it, right? So we can't, so here's the problem. If a problem is what is called open and obvious, the judge will throw out your case, because the law in Illinois says if there's a problem in front of you and it's easy to see and it's big, you have a duty to avoid it. The property owner doesn't have to protect you against it, because adult people are expected to protect themselves against open and obvious dangers, right? So that means if there's a giant hole on somebody's property, you're supposed to see it. They don't have to fix it, right? Now, the exception is, so here's the bear trap, right? If we say the hole is big enough or the problem is big and obvious enough that the owner should have fixed it and should have discovered it, that cuts against us, because why didn't you see it? Why didn't you see it? If we're saying it's a big, obviously dangerous problem, why didn't you see it? You were the one standing there. Why didn't you see it? How is the owner, with a million other things on his mind, trying to run a business, how is he supposed to see a problem on the floor? And you're right there and you just miss it. Okay? So unfortunately, the law is if there's an open and obvious problem, you're on the hook for it. So that's like the bear trap. They got you coming and going. But here's how we get around it. There's something called the momentary distraction and the deliberate encounter exceptions to open and obvious, okay? So that means if there is a problem in a walkway that the owner of the property knows that people have to use to get from point A to point B, or if it's reasonable that they know that people will choose that route because it's the most direct route, You get this a lot in like cases where it's near an entrance and exit door. There's a problem near an entrance and exit door. Even if the problem is open and obvious, the property owner knows that people are going to go in and out an entrance and exit door a million times, and it's inevitable that there's going to be an accident, right? So that's one way we can get around open and obvious, even if it's a big problem that the court would otherwise say that you should see and you should have avoided. If it's open and obvious, then we're in trouble. But if it is deliberate encounter, like meaning a reasonable person, because like it's a straight shot for you and it's the best way to get in and out of the house, deliberate encounter defeats open and obvious. Momentary distraction is, we see this a lot in grocery store cases, or in bars or restaurants, or even like work zone constructions. If there is a distraction, so you're walking and, for example, they have big signs about a sale, or you're looking for peas, not green beans, and you're on the shelf and the defect is right under the shelf under a big sale sign. Well, the store owner makes money by having you look at that sale sign and buying more stuff. So that's a momentary distraction. So if you were momentarily distracted, preferably in a way created by the owner of the property, fantastic. But even if the distraction is foreseeable to the property owner, there's case law in Illinois that says you defeat open and obvious, right? So I hope that wasn't too confusing. Here's the Reader's Digest. If you fall down and what caused you to fall is open and obvious to everyone, the court might say no case for you because you have to protect yourself as an adult against obvious things. But if you are momentarily distracted, or if you are aware of the problem but you encountered it anyway because it's like right in the entrance or exit of a building, or some location, or a pathway that is obviously something that a reasonable person is going to use even with the defect, even with the thing that made you trip, then open and obvious doesn't beat your case. So sorry for using some legal terminology. I hate doing that because it puts people to sleep, but I thought it was important for you to not get caught in the bear trap, right? So I screen for all of this sort of stuff. Sometimes people who have a fall down get mad at me because I ask them so many questions right at the beginning, and they just want to tell me my story and hear good news from me. They want to tell me what happened, and then they want me to tell them they got a great case and we're going to get them a bunch of money. But I'm honest, I think fall down cases are tough, and you need a good lawyer who knows what he or she is doing and asks questions and does investigation. I once worked as a young lawyer at a couple of different law firms who treated fall down cases no different than car crash cases. So that's a big mistake. Fall down case is 3 or 4 times harder to win than a car crash case, and they require way more work early on. So if you're just treating them like a car crash case, you're in trouble, buddy. You're in trouble. I learned that real fast at my first job. I'm like, man, we need to change the process at this joint if we want to win any of these cases. So anyway, thank you so much for watching. I hope you and your family are well. If you know anyone who's been injured and needs a lawyer, I sure would appreciate the referral. You can ask them to call 312-500-4500, or you can call and leave their information for me. You can call that number anytime, night or day. The consultation is 100% free, no obligation. So that's 312-500-4500. I have some great tools on my website, like the Case Cash Calculator, tells you what your case might be worth, or the Good Case Calculator, which tells you whether you have a good case or you have a case with some challenges. Both of those tools are free. They literally take 15 seconds to do, and they give you great information. 100% free, no obligation. Links in the description. If you enjoyed the video, please give me a thumbs up, and please consider subscribing. And if you do, hit the bell icon so you get notified when I release a new video. Finally, if you wouldn't mind giving me a 5-star review on Google, that would really help me. All you got to do is go to the link in the description, cut and paste it into a browser, click 5 stars, say a kind word, hit submit. Only takes you 5 seconds, but it is invaluable to me, and I would really appreciate it. So thanks for watching. I hope the information helps you. I hope I didn't put you to sleep in this one, and I hope you have a great day. Take care. Bye-bye.